I've enjoyed my association, continuing association with Benevolent Irish Society since then. And people like George and other of my friends in the society make sure I get reports and know what's going on, so I follow it with great interest. I'm surprised and delighted to see such a turnout on a Friday night in Prince Edward Island to listen to a talk about laws that are 2,000 years old. So I'm sure there are other interesting things going on, but I'm very, very pleased that so many are here, and particularly so many of my friends, old friends, some who I haven't seen for so many years that I won't embarrass them by telling them how long. But it was great to see so many people. This is a subject that is a dull subject, often, law, particularly to those who aren't involved in the law. And the only thing that can make it duller is a judge delivering the address, because as most lawyers will tell you, Mr. McKenna will confirm, I'm sure, most judges are seen by the profession as being perhaps the least knowledgeable of all about the law. But I can assure you that the information about the Brehon law is good. It's not boring unless I make it so. So if you have a dull time this evening, it's not the subject, it's me. It's a subject of interest not only to legal academics, but and historians, but also to everyone of Celtic heritage, who are interested in the basis of their character and the basis of their roots. It goes to more, I suggest, than just knowing who your ancestors were several hundred years ago. I think as I talk about the Brehon laws to some extent and give you some idea of what the Celtic peoples were like now, at least a couple of thousand years ago, you will begin to see in the laws themselves a picture of a people who are not too dissimilar in some characteristics to the current Irish, and I suggest to you to the Irish of Prince Edward Island, who I was so familiar with and grew up with. I see evidence of them throughout these old laws. Now, the Brehon laws, before I start, I have to apologize for anyone who can speak a bit of the Irish tongue for my pronunciation of the Irish words that I'll be using. I've sought a little guidance, but I know I'm going to be making lots of mistakes, and I'll try and cover them up as I go along. So if you hear me slurring words, it's because I don't know the pronunciation of some of the Irish words. So the Brehon laws was a code of laws developed in Ireland by the Celts, who were a great wave of Celtic tribes who spread over much of Europe in the 5th and 6th century before Christ. And although it was formerly believed that most of the Celts who ended up in Ireland came through Britain, most scholars now are convinced that the Celts in Ireland came from a seafaring tribe of Celts in the northern Iberian Peninsula in what is now northern Spain. The Celts were a tribal society, and those who came to Ireland brought with them tribal codes of law designed in part to modify the instincts of a rather raucous, warlike people. And because pre-Christian Ireland was an unlettered society, their language was not a written language, writing wasn't part of the culture, one would have thought that because of that today, that the laws of that era and other aspects of the culture would be lost. But the great reputation for Irish learning is not based solely on the famous Christian Irish scholars of the so-called Dark Ages and the scholars that followed. Well before St. Patrick arrived in Ireland in the 5th century, the Celts had evolved a marvelously structured social system based on numerous grades of social status, ranging from the kings and chiefs on one end of the list of status down to the serfs and the slaves. And you'll remember that Patrick himself was a slave in that society before he was educated in the church, escaped and educated in the church. So the basis of the system was rank, training, and worldly possessions. But central to the old Irish Celtic system were the Brehon laws. or the Brehon Code, and they were named for the wandering jurists or judges of the island who were called Brehons. So the Brehons were the men and women who interpreted the law and had the agreement of an entire population as to what controls the people would accept. So the mightiest kings of Ireland in the old Celtic period were not as powerful as the Brehon laws were to Celtic Ireland. Those laws had their roots, as I said, in the Celts who carried them with them in their migrations across Europe over several centuries. But in Ireland, the laws gradually developed by custom and by decisions, particularly the decisions at the great assemblies at the holy places, such as Tara. And although rank was relevant in ancient Ireland, in most cases all freemen could participate in those gatherings and played some role in those gatherings. So although it was a race-conscious culture, the free person had a role in the law-changing process, which is, of course, the basic element for any people to accept the supremacy of the law, or the rule of law as opposed to the rule of men. In fact, the Brehon laws were rarely legislative enactments. They weren't laws made by the state, or even most of them weren't laws made by the assembly. Most of the Brehon laws had their roots in developed custom. A substantial body of these laws relied on the precedence of one Brehon passing his judgments on to another, much like our common law system. And they were also based on the commentaries, the verbal oral commentaries that the learned lawgivers and Brehons made when they made decisions. The whole basis of the civil law, the Brehon civil law, was based on contract. And imagine the distinction of their law to our law of contract, where it all had to be based on verbal or oral agreements, as opposed to our system now, which is substantially based on a written contract. So the Irish had been living by those laws before the Romans entered Britain. But the Brehon laws survived, at least in parts of Ireland, throughout the incursions and the settlements of the Norsemen, throughout the Norman invasions and the settlements of the Normans in the 12th century. That is the area of Ireland around Dublin called the English Pale, until the period of Elizabeth and James in the 17th century. And then at that time, the English conquerors considered that the Brehon Code and the influence of the Brehons or the judges was a danger to their power and to their realm. And they decided that the old Brehon laws were, quote, lewd, unreasonable, and barbarous. And so they banned the Brehons, they banned the poets, and the ancient system of laws, and they replaced them with the English common law. And that was the end of the Gaelic order in Ireland until recent times. But after St. Patrick and his followers brought Christianity to Ireland in the 5th century, the Christian clerics wisely adopted many of the Irish customs and the Irish laws into their system of religion. And with some modifications, they adopted and accepted the Brehons and the Brehon Code. Their greatest addition was to write down these laws, both, of course, initially in Latin and then later in the written Irish language that they had developed by the 7th and 8th century. But when the English did ban the Brehon laws, they also banned the manuscripts, the written laws, because the native Irish attempted to keep these laws and to apply them as much as they could in their own affairs. So many of the manuscripts were hidden, and many of them were buried in urns, and they were hidden behind fireplaces. They were lost, of course, and deteriorated over the years, but some fell into the hands of collectors and were otherwise restored. and they're now safely in the hands of Irish and English institutions, or in European collections, because the Europeans have an enormous interest in the Brehon laws because it shows a Celtic society before medieval and Roman influence. One authority has called these law tracts, revived law tracts, quote, probably the most important documents of their kind in the whole of tradition of Western Europe. Mind you, that authority was Irish, and you might expect a bit of blarney, but this assessment isn't really an empty one, as their value rests not only in their great antiquity or their extensive information on an ancient culture, but also because it described a Celtic people, unlike the Celts in England and Britain and the other parts of Europe, who were not conquered by Rome. And thus they had a Celtic culture with unique laws which flourished for 2,000 years, not significantly affected by outside influences other than the modified brand of Christianity that St. Patrick and his followers brought to Ireland. Now, it may be helpful in understanding the laws of the ancient Irish to note the most significant difference between those laws and our own understanding of modern law systems. Each tua, or petty kingdom, of Ireland was a separate jurisdiction. Some of the tuas were occupied by only a few thousand people, ruled by a king. It was mostly an agricultural society with very few population centers. In general, there were no standing armies or bureaucrats. Some minor exceptions to that. The tuas had very little machinery of government. General wealth and status, except for the categories I'm going to mention later, were measured in cattle. Fines were measured in sates, with 2 sates being roughly the value of a milk cow. But you must remember that we're discussing laws as well that changed to some extent over that 2,000 years, as was inevitable. And therefore, when I indicate the value of a fine or the value of some aspect, I want to remind you that I'm selecting a certain period of history, and there would be probably some changes in those over time. Now, the first significant difference from the modern laws was that all proceedings were in private. That is, an action, any kind of an action, criminal or civil, was initiated by one of the parties and not by the state. Presumably, this was in part caused by the very rudimentary nature of state administration in the Celtic society. The second important difference was that the law was interpreted by the Brehons, who were not part of the state system. They were not judges as we recognize them today, who are one of the institutions of government. And as well, these Brehons or judges were respected and accepted not only because of their knowledge of the law and the respect for their learning, but because it was believed that they were acting on behalf of a divine power, and that divine power directed their judgments. In the most ancient times, the Brehons were a specialized class of the Druids, and who were, of course, the holy men of the Druid religions. The several classes of Druids initially in the early tribes not only had lawgivers, but they also had poets and they had musicians, as well as those who were sort of the priests as we understand them. So in the Brehons and in their judgments, part of the early respect grew out of that religious background, in that they were the spokespersons of the law, but they were bringing to the law a religious aspect. The final important difference from modern law is the importance of honor price in the law. The honor price was a value placed on a person's rank, which had to be paid in whole or in part if the person was injured or offended against. Loss of honor, and thus loss of rank, was also a very severe punishment for the Celts. So I'm going to discuss with you both the nature of the brehons and their background and honor price, so that you will, in greater detail, so that you will get an understanding of these two principles that were so basic to the understanding of the Brehon Code, and also to the manner in which the old Celts lived and what they believed to be. The Brehons, as I said, didn't fulfill a position as our judges do today. The Brehon was more like an arbitrator than a judge. But he or she was so scholarly and so wise, and their statements regarding the law relating to some particular dispute was so venerated, that usually the awards that they made were treated as sacred. Everyone in the community considered that they had an obligation to see that the pronouncements of the Brehons were respected, and, if necessary, enforced. Rarely in history has public opinion played such an important role in the enforcement of laws. Often our laws, of course, in present day, are enforced by the state, but this was not the case in most of legal enforcement in the old Celtic system. It was rare that anyone dared to reject the statements or the decisions of the Brehons. If a first person felt that someone owed him money, and after going and receiving a decision of the Brehons, and that other party refused to pay, the creditor might try to bring public opinion to bear by fasting at the debtor's doorstep until public embarrassment or public opinion forced the debtor to pay. And during part of the Celtic era, often even the person who refused to pay felt obliged by honor to, even because he disagreed in the decision, but nevertheless was under such public pressure, to fast himself or herself. And you would have the two of them fasting. One had to break, and it was usually the debtor. This was particularly useful if the debtor was a high rank or very powerful, and that person's honor was thus publicly questioned. The fasting, I suggest that the fasting that we have seen in the past several decades in Northern Ireland has its basis in a technique that was used among the Irish for thousands of years to achieve their rights against the powerful. Force and seizure was thus not often required in a culture where the law was so respected. So the Brehons were thus more of a legal expert who devoted his or her life to arbitration for a fee. The fee was usually about 1/12, arguably 1/11, and some authors say 1/10 of the amount in dispute. Sometimes they also gave advice, much in the sense that some of our lawyers do today. Often they gave advice to the rulers of the Tuatha. Each king or petty ruler would have a Brehon advise him on general administrative matters, on what the king's legal responsibilities were, and on disputes that had to be dealt with by the king. But the Brehon was an important officer at all royal courts. In fact, the general rule was that if the queen was unable to attend a great feast, the Brehon sat to the right of the king as a symbol that he or she was the spokesperson for that king. So in an unlettered society where nothing was written, you can imagine the training that a Brehon must have to go through to understand and master the Brehon law. A person who aspired to become a Brehon had to spend years, many years, in attendance with a Brehon, learning the laws and the precepts and the maxims of famous past lawgivers. All of these had to be memorized with perfect recall. Not a word, not a phrase, not a line wrong. So you can imagine the power of memory that these people had to develop And this memory base, of course, was not only necessary for the Brions, it was necessary for those who told the stories, for those who recounted the legends in music. Fortunately for us, many of the laws and commentaries, as I said, were written down starting in the 7th century, and they are the source of our knowledge of the culture as it is today. But even when they wrote down the old laws in the 7th century, they were repeating what had been repeated for hundreds of years, with minor variations, I'm sure, creeping into the changes as they took place. And so we will find in one of the texts, the Briatha Bridget, which is loosely translated as the Judgments of the Wise Bridget, a woman, by the way, and by that translation, her works were brought down to us. And the suggestion is that Bridget initially was one of the Celtic gods who became a lawgiver in legend, and some suggest that even, and dare I say this here, even the famous Saint Bridget may have been a continuation of this famous Bridget. What did happen, because of the great respect given to learning and the law by the ancient Celts, is that when they did tell their legends and they did tell their stories, the Brehons became as revered and remembered in the culture as the famous warriors of legend and the great kings of ancient Ireland. There was also Brian, you'll be glad to know, there was also a class who argued the law, advocates somewhat similar to our lawyers today, who had a lower status than the Brehons. They were lawyers not unlike those of our own, as I say, who were paid to argue cases before the Brehons. But as happened in our legal system, and some will argue is even happening today, the people of the law in Celtic Ireland indulged in the vanity of exclusiveness and wrapped the law in obsolete language so that only the chosen, the lawyers and the judges, could understand it. And the great Cormac MacArt, one of the more than legendary, the historic rulers of Ireland, became so angry with such a development that he deprived the poet orders, and they had their exclusive right to practice law. He deprived them of that right and opened the right to everyone. In one of the old Irish written texts, it was reported that King Cormac was asked what were the worst practices of lawyers, and he responded this way. And perhaps again you might listen to the rhythm of the words, because you will note that often even in translation you can see them as an aid to memory, to memorize these lengthy laws. And this is what King Cormac answered when asked the worst practices of lawyers. Contending against knowledge, contending without proofs, taking refuge in bad language, a stiff delivery, whatever that means, a muttering speech, hair-splitting, uncertain proofs, despising books and knowledge, turning against custom, shifting one's pleading, changing pleading, I believe, inciting the people, blowing one's own trumpet, and shouting at the top of one's voice. So perhaps old King Cormac's wisdom could still be followed today by us in choosing and assessing the qualities of a good lawyer. Now, the next area I want to cover is that of the honor price, because it's so important to understand, in the understanding of the Brehon laws, is that concept. As the early Irish society was hierarchical, an offense against a person of higher rank usually resulted in a greater penalty against an offense against a person of lower rank. This eventually changed somewhat in the Christian era when the distinctions in rank became less significant. But the measure of a person's status was his honor price, which had to be paid for any major offense against that person. The penalty could be different for offenses which didn't involve a person's honor. The honor price of a male freeman, and only the free people had an honor price, and only the free people had an honor price. It ranged from the honor price of a king, which was 42 milk cows, and that is for a provincial king, down to a yearling heifer in the case of a young man still living on his father's land. The honor price of a person's wife, or a man's wife or children, was usually about 1/2 of the honor price of the man. A person's capacity to perform legal acts was linked to their honor price. So an individual couldn't make a contract, for example, or be a surety on a contract beyond the amount of their honor price. A person's honor price also determined the value of their oath in a legal process. The lowest classes, as I said, did not have an honor price. And those classes included those who were tenants on another person's land, or those who were bound to the land, in somewhat like the medieval serf, and to the slave. And don't forget, Patrick at one time was a slave in Ireland. Rank, however, unlike many feudal societies, could be changed. A king who showed cowardice in the face of battle could have his rank reduced to that of a common freeman. But a legal maxim existed in the old Celtic laws that read, and you will hear this in the tongues of your own parents, I'm sure, a man is better than his birth. And an increase in status could occur, often based on art or talent, and even based on whether a person was a competent farmer. If a competent farmer built up a wealth, usually in cattle and land, to the level of a lower class of noble, for example, and maintained that in the family for 3 generations, after the 3rd generation, achieved the level of nobility that they had reached in wealth. So it was in recognition of skills in the arts or in learning, because as you already will have heard from me, the respect for learning was very high among the Celts. Unlike many ancient societies, including many modern ones, such as the United States, many of the states of the United States, the penalty for killing another person was rarely death. Irish law allowed for atonement. It seems that the Brehon laws allowed, in fact, 2 types of fine for a killing. One of them was the honor price of the deceased, and the other was a fixed amount called an eric, which was more or less a compensation price. The death fine was distributed among the kin or the family of the victim, and the kin played a significant role in Celtic culture, and the kin is called a fine, F-I-N-E, a fine, and it means a family group. And roughly speaking, you could say it was the descendants of the same great-grandfather, but obviously that would change in time. As the fine was frequently based on honor price, and the honor price was graduated on a scale according to rank, then the sword of justice cut 2 ways. To those to whom much was given, much was expected by way of fines. A far higher fine, for example, was also expected for the theft of an embroidery woman's needle than the theft of the queen's needle, regardless of the value of the needle. Because, of course, the obvious reason is the reliance that that skilled person needed for that article. The most effective punishment, however, was the reduction of a person's honor price. although it meant that the person would pay a lesser fine for future offenses because their rank and their honor price was reduced, for a person, particularly people of high social rank or high intellectual rank, a reduction of honor price meant that that person was degraded in society by being reduced to a lower rank. Not only were the kings and nobles subject to greater penalties, but after Christianity, so too were the clergy. For example, where for some crimes, if a person committed an offense on the first occasion, they may have lost half their honor price. By the time they committed that same offense 3 times, they had lost all of their honor price. But for the clergy, to lose or to commit an offense, they lost all of their honor price for the first offense, and they were degraded. However, for most of the clergy, by prayer and penance, they could regain their rank. But most interestingly, one particular status of clergy could not retain their rank, and that was the bishop. A bishop lost all his honor price on one offense and also was forever deprived of his rank. It could never be restored. And not only that, the bishop was banished from the Tua, banished from society, and had to live as a hermit. Now, I do not want you to believe that the honor price was only for the learned and the nobles. In this class-conscious Celtic society, people with certain craft skills also ranked higher than others. One of the unearthed legal texts assigns honor price based on sates, which is a measure of currency. And I should know, I've forgotten, but I think it's roughly an ounce of silver for 2 sates. Or I know it's 2 sates for 1 cattle, but that's approximately the value of a sate. From this we can measure the value placed on that occupation in the old Celtic society. For example, a physician or a doctor had an honor price of 7 sates. And that honor price didn't change regardless of the skill or the increase in the knowledge of that doctor, or even the increase of the doctor's reputation. However, a person who works with wood, a wright, millwright, a carpenter, a builder, could have a changing honor price depending on the skill achieved. If a woodworker mastered the skills of boat building, church building, and the making or fashioning of articles in yew wood, the honor price was 7 sates. But if that craftsperson mastered all 3, the honor price increased to 15 sates. And with further qualification, the honor price could go as high as 20 sates. And from this you might measure the respect and as well as the importance to some respect of craftspeople in that society. And I would note for those who enjoy this type of information that in the oldest Celtic societies there were women craftspeople in these categories. There were women wrights, for example. Now, 20 sates obviously is significantly higher than the 7 sates of the physician, and it's also substantially higher than the highest grade of brehon or judge. So the brehon to the high king had often a lower honor price than that of the most skilled craftspeople. The next most prominent crafts were the blacksmith, the silversmith, and the coppersmith, with an honor price of 7 sets. At the level of 3 sets stood the engraver and the chariot maker, and lower still was the leather worker, the turner, and the ring maker. And only one entertainer had independent status in the society, and that was, of course, a guess, the harpist. All other entertainers had no honor price in their own right. They acquired them usually through a patron, and they relied on their patron's honor price. So thus, contract played a major part in the Brehon laws, and in a substantial way, the contracts were based on honor price of those who participated in the contract. For example, a person may already have dealt with contract and honor price. If I have, please excuse me. But have I mentioned that a person couldn't enter into a contract for an amount greater than the honor price? I have gone through. See some nodding yes and some nodding oh. No, I'm curious about that response. But anyway, these restrictions may have served to limit commercial activity, but the other party in the contract could rely on the honor price, not only of the party who entered into the contract, but also the surety, or the person who guaranteed the people involved in the contract. So it was a very secure contract. A person without an honor price couldn't make a contract unless a person with an honor price acted on their behalf. But it should be noted that some contracts could be entered into without sureties or without guarantors. And those included some interesting professions. A poet didn't require a surety, contract with a poet, or a contract with a lawyer, or with a smith, or with craftspeople, and as well the contract for fosterage. It was a Celtic custom, broad Celtic custom, to bring into a household someone who was not a member of that family and raise them. And thus there was an interchange not only of customs, but also an interchange of learning in the society. And a contract for the care of the aged did not require surety. And probably the interesting part of that was that they did have contracts for the care of the aged 2,000 years ago in Celtic Ireland. So the Brehon Code concept of honor price played a great role in many aspects of the lives of the ancient Irish Celts. And one presumes that it developed because as a tribal society, the greatest glue, the greatest mucilage of a society was the reputation one had in such small communities. And within a relatively integrated community, people relied on one another, and thus it was important to maintain your reputation. The enforcement motive of the loss of an honor price meant the loss of status in the eyes of the community, a considerable loss for the ancient Celts. For them, the loss of rank was exceeded in punishment only by being ostracized. That means being sent out of the tua that they lived in, or being ostracized within the tua. That is, no one would speak to them, and from that you might see some semblance of later Irish laws where they punished, where the Irish, when ruled by the English, often punished the English and those who cooperated with the English by ostracizing them from the community. Now, the crimes of the Brehon laws are very similar to those of many agricultural and tribal societies, but I suggest to you that the Irish expressed them with more panache, perhaps, and enforced them with more fairness than many other societies, even modern societies. And I will not list for you, I promise, the many crimes of the Irish society, fascinating though many were, because of the time limits tonight. But they did have laws. For example, one example I will give you, they did have laws that dealt with the building of fences between stock. And the laws specified how high a fence should be for cattle, for example, how thick it should be for pigs and chickens, different thickness, different weave, and so on. And those who breached those laws were severely punished because it was this stock was the important part, a most important part of their wealth. And there's fascinating information as to how they valued these different animals, the different scales of value, which you can measure the farming culture and the agricultural culture just from reading the laws. But let me give you some taste of how their laws was categorized by one translator of some of the old texts. And again, perhaps as I read it from a translation of the text, I can give you a sample again of the rhythm that helped the Brehon laws be memorized by those that had to memorize them. And this is the quote: "Fivefold are crimes: the crime of the hand by wounding or stealing, the crime of the foot by kicking or moving to do evil deeds, the crimes of the tongue by satire, slander, and false witness, the crime of the mouth by eating stolen things, and the crime of the eye by watching while an evil deed is taking place." Now, some of those crimes are obvious from our own culture, but two of them are perhaps interesting. Most interesting. One of them is the crime of the eye, because we have basically no crime in modern society that I can think of as I read on this subject that equates with a person being charged for an offense for standing by while a crime occurs. The ordinary citizen is not charged for that crime. Whereas in Celtic Ireland they were, because the people were required to enforce the law. There was no enforcement system, no government enforcement system such as we have today, no police system, and even the king had very few people to enforce the law, because there were no standing armies, basically. The second interesting one mentioned there is satire, the law of satire. The ancient Irish had laws against verbal abuse and insults. In effect, laws against satire. Appropriately enough, the fines for such an offense was called a blush fine. Presumably, among a people who had such a high regard for their dignity and their honor, insult could easily give rise to violence. So the wisdom of the Brehons was to make insult and satire an offense subject to punishment. Blush fines were payable by people of all ranks, with very few exceptions. But the exceptions, again, are the interesting one. You could insult a certain classes of people without being subject to an offense. And one of them is translated as the ne'er-do-well, presumably the person who does no work and doesn't contribute to the community. The second is the selfish person who cares more for his stock than he does for the people. The third is the public clown, that is, the person who makes a profession of saying nasty things about people, so you could say what you wanted about the clown. And then, of course, the satirist, the person whose occupation was satire, fell into this category, and I will discuss the satirists to some extent later. Another notable exception were the lawyers. Now, Brian, I have no intention of focusing on lawyers, but they are people of the law, so I must discuss them. And this is because, and the reason is written into the law, so I'm going to quote from the Old Irish law, or a translation of it, but for the reason why the lawyers were an exception. And it's as follows: a man who is paid to abuse others is not entitled to claim damages when he abused himself. Wisdom is also shown in that the law would not allow a claim for a blush fine from a person who looked after the poor if the poor insulted him or satirized him. So there was balance in all of their laws. The law, in fact, listed different classes of abuse or satire that was punishable by fine. These included mocking a person's appearance, or talking about a blemish that a person had, a physical blemish, or composing poetic satire or repeating the poetic satire of another, a very powerful weapon. To wrongfully accuse a person of a crime, or to gossip about a matter causing shame, was also an offense. An interesting aspect of this area of the law is that if the satire was justified, in other words, if you gossiped about a person, about a matter causing shame, and the shame was in fact something that had occurred, then all that was necessary was a public retraction. But if it was justified, the fine was usually the honor price of the person satirized. According to one authority, if a poet satirized the king, and this is the poet, satirized a king, then the satire was cancelled by the poet writing a praise poem about the king, about how marvelous a king he was. And the law read he had to write, quote, a praise which washes away satire. Interestingly, it was an offense to ignore satire. If a king or a noble ignored satire, that itself was a major offense, because it was expected that they must extract compensation, or they would forfeit their own honor price. But sanctioned satire was legal, and sanctioned satire became one of the rules or methods of punishment. It could be included in a punishment by a brehon. And it was a powerful tool. The legitimate satire was carried out by the professionals, the poet class, because satire and praise were among their main functions. Now, as I've already noted, most punishments were meted out in the forms of fine and compensation, called eric, with or without loss of honor price. But, as I mentioned before, the death penalty was never pronounced by a brehon in a law court. Violence was never condoned by being sanctioned by the brehons. Violence was never a part of their punishment sanction. Now let me move to an area of special interest to some, perhaps, and that is the role for their judgment. They could use the scripture as part of those reasons. So the scriptures and the Bible became a significant part of the brehon law after Christianity. Women generally, though, could not act as witnesses or make valid contracts without permission of the husband, if married, or the father, if not. However, women could testify about some subjects, and on certain subjects, such as sexual matters, their evidence was conclusive. In other words, whatever the man said was not accepted. For example, as well, a woman cleric had special rights, and she could testify against a male cleric. Women could pledge personal property and make contracts in relation to personal property, but not cattle, horses, or precious minerals. Irish canon law based the reason for not granting women the same value in testifying as men in this way, quote, the testimony of a woman is not accepted just as the apostles did not accept the testimony of women about the resurrection of Christ. That was the reasoning. It would seem, however, we must look back and say that this was a period of Christianization that lasted for more. Patrick didn't accomplish it overnight, so it lasted for a long period of time. But however I read that, it seems that the fact that the women in question were right about the resurrection doesn't seem to have struck the monks about the value of their judgment and their assessment. Now, certain women of status or skill of great importance to the kingdom or the tuath had independent legal capacity. In most ancient Ireland, a woman could achieve the status of physician or brehon, or, as I mentioned earlier, as a right, and be granted the status of that position. crimes against women entitled their guardian, whether the father or the husband, to his honor price. And with reference to female inheritance, a daughter was entitled to a share of a father's personal property, but not to land unless she had no brothers. Only if she married a man from outside of the Tuah, in other words, somebody who came from another Tuah or another kingdom, who couldn't own land himself, then under those circumstances a woman could pass a portion of the land to her sons. Now the Irish had many forms of legal sexual union, marriages, so to speak. They had as many as 9, and I will not repeat them all, but I have a text that recites them that is beautiful poetry and fascinating to give you a glimpse of their society. But polygamy existed, and having concubines, but in a legal marriage state, existed, and in fact survived the arrival of Christianity. It was more powerful than the Romanized Christianity that Patrick and his followers attempted to bring to Ireland. If a child is born of a union forbidden by a man's father, the girl and her kin, or her finna, would raise that child. But the opposite happened if the girl's father had forbidden the marriage or the union. And that is, the husband had to, or his family had to raise the child. The husband had to pay a bride price to the father, and the bride was entitled to a part of it, something like our dower, or older dower rights. The basic and most important fact about their children and their marriage systems was that a child born in any of the 9 levels of marriage, and that included a soldier's marriage, which was an overnight encounter, all children born of that marriage were born legally, and they were born within the law, and they had legal rights. And in some ways, that system was more humane than even our system going back 20, 30, and further back. Whereas there was practically no persons who had the classification of bastard in the old Celtic laws. All children were important. Now, both families contributed to the property of the newly married couples. Marriages, of course, of equal rank were encouraged, and that really hasn't left our society too much, although it's gradually leaving. If the marriage was unequal, the family with the lowest rank had to contribute more cattle than the other family. There was divorce, as the divorce for many reasons, and the right of divorce was with the wife as well as the husband. A system of divorce which is only in the past few weeks has finally returned to Ireland, but they had many other grounds for divorce than even the present Irish laws. Grounds for divorce included impotency, one of the parties being too fat for intercourse, practicing homosexuality, sterility, or one of the parties choosing holy orders. And that was an option, of course, after Christianity. Not only that, in the Brehon law, there were many grounds for legally permitting a separation for a period of time. And one of those allowed either party to seek a child elsewhere and then return to the marriage. And the law said they could do that, quote, without penalty. Whatever the penalty was, I don't know. Now, the last, let's say close to the last, matter I want to talk about is the laws of hospitality, which is different than any modern law that I'm aware of. The ancient Irish laws placed a great emphasis on the duty of hospitality. One of the people with the highest rank in the society was the hospitaller, who had the duty to provide hospitality to all free persons. To a lesser extent, the obligation to provide hospitality was the responsibility of all householders. It was an offense not to provide food and shelter to those entitled to it, and the penalty depended again on the rank. This duty was also placed on women, and among the offenses for which a woman could lose her full honor price was one who refused hospitality to a law-abiding person. Hospitality, however, had to be refused to the criminal or somebody living outside the law, and it was an offense to give hospitality to such a person. The Brehon law extended the obligation of hospitality to an obligation for the protection of those who visited. A freeman was obliged to give protection not only to those within the household, but also to those who visited for a limited period of time, usually about 10 days to 2 weeks. It appears to be a form of sanctuary or refuge, somewhat similar to the cleric or the religious church sanctuary. Thus one can see in this the roots of Irish reputation for hospitality and the reputation of ourselves and our ancestors in this island for hospitality. That root is deep in the ancient law, where hospitality wasn't only a duty, but it was one enforced by law. And I see it today. This weekend I have one of my nephews, Wilford, out at the airport giving me his car for the weekend. I have my sister Loretta opening up the house to other people to come and visit when I'm here, and my nephew Billy Butler offering me bed and board for 2 weeks. I promise you guys, if you hadn't have done it, there was no penalty. Now, let me close with some comments about how the ancient Irish treated bad judges. So, Brian, you wouldn't feel so alone then. In addition to the earlier comments that I've made regarding judges, I should also point out that they had to take some risks if they made decisions contrary to the Brehon law. And I think, George, you here might appreciate some of this as well, so I don't have to take all the heat for bad judges. Not that you were one, but a judge or a Brehon was obliged to give 5 ounces of silver as a pledge in support of his or her judgment. And a judge had to pay a fine for a wrong judgment. The judge who left a matter undecided and failed to make a judgment was subject to an even greater fine of 8 ounces of silver, a great amount of wealth in those days. However, if a judgment was challenged, appealed, so to speak, in our language, and it was shown to be correct, then the judge was entitled not only to his or her fee, but a fine as well. And for every serious breach of duty, a judge could be removed from office and lose his or her honor price. But one of the great punishments that the judges had to risk in those days was related perhaps to the magical aspect of the law that came from the Druids and the Brehons who were originally Druids. And that is that anyone a judge who was influenced by bribery or who purposely made a mistake, or deliberately, I should say, gave a judgment contrary to the law, was believed to appear that a red blotch would appear on the judge's cheek. And this is a matter confirmed over centuries as having some validity. And if a biased judgment was pronounced, then that is what would happen. And it would only go away if the wrong was corrected. So the judge had that continuing moral obligation sitting over his or her shoulder that if they deliberately gave a false judgment, so to speak, that people would know about it. And because of that, perhaps the red blotch often appeared because they expected it to appear. One of the old legal texts reports that one of the 3 falsehoods which God most avenges on a kingdom is a false judgment secured by bribery. So the honor of the judges was held very sacrosanct. And it was obviously, perhaps, George, more risky being a judge in ancient Ireland than it is today. So thank you very, very much for your attention. I enjoyed the subject, and it was brought up, I must tell you, I had a friend of Jewish heritage who visited Ireland about 4 or 5 years ago and came back just enchanted with Ireland and the hospitality of the people of Ireland. He could not believe the reception that he and his wife received, and he brought back a little memory book for me, and it was on the Brehon laws. And about a year ago or so, I was at a gathering on the island here with George O'Connor and my brother Jimmy, and George was talking about this lecture series, and Jimmy volunteered my services to come and speak about a subject. And I did not want to lose my honor price, so I accepted it. So thank you again for your attention.
Marvelous presentation. We've been after Justice Kelly for 2 or 3 years now to give this presentation. Yeah. But it was well worth waiting for, and really I don't think I've ever seen the audience so attentive. It's a great audience and a great presentation.
Mind you, from the back, it might have been some sleeping too, but I don't want to take too much credit for that.
No, George Mullally was there.
Well, George was covered.
He was concerned about the sanctions on the judges. Justice Kelly has agreed to take a few questions if you have any.
I have one caveat, and that is I am not steeped in the Irish tradition or the Celtic traditions, and in spite of having an opportunity to read a few texts on the law, I frankly am not that deep in it, but I will do my best under the conditions. Yes?
You use the word fine. I take it that's not a fine in the sense that we understand it.
Yes, but it's more in a compensation. Like we have usually fixed fine for something, but the fine, which I think was pronounced the eric, it's spelled in 2 or 3 different ways, was more of a compensation depending on the nature of.
So even in the instance of offenses,
Yes.
there would have been a private complaint, probably by a neighbor.
Yes.
And the compensatory fine.
That's right. And it even went further than that. I mean, there's so many fascinating things about it. Whose cow caused it if there was a common field, for example? They couldn't decide that, but they had a method for determining that. And the method was they would keep all of the cow and they would draw a lot. And the owner of the cow who lost in that lot was presumed to be the owner of the offending cow. Someone else has a question, but I have to tell you another fascinating thing that we could learn about the wisdom of these ancient people. When we have an inheritance that depends on the division of land among several people in a family, we have great difficulty dealing with that, because which piece of the field or which piece of land is better than the other? How do you divide that? And we have struggled with that in the English common law for 8 centuries, and we haven't mastered it. The way the ancient Brehons mastered it was this way. If there were several sons entitled to the land of the deceased, the youngest son did the division. So, and the division, the choice started with the oldest son. So by the time they got to the youngest son, the division had to be very honest if he was going to get an equal division. It works. I can remember my mother doing that for us when we were fighting over a piece of pie. And I believe you, when I read that, I was thinking, you know, does that knowledge come from some tradition that carried on, that a division is best done by the person who last chooses? It's simple. Yes, there was a question back here.
Yes, when you spoke about when the Brehon law was finished, was over, and English common law came, was the Brehon law then gone, period, or did it, was English common law influenced by it?
It's difficult to say, but it's quite likely that it was, and the Brown law didn't go away overnight. The English, of course, were there with Strongbow in the 12th century, around the Pale. But a fascinating part of that was, even though the English, or the Normans really, were there, for a period of time, and they had the experience of both the Norman law with its English mixture, its Anglo-Saxon mixture, and the Brehon laws. By, I think it was the Statute of Kilkenny, I wish Father Kelly was here, or he would know those things. The Statute of Kilkenny, they adopted the Brehon laws rather than their own laws. But then the Brehon laws continued in various parts of Ireland, and the parts that gradually became more English with the settlements of the 14th, 15th, and 16th, and 17th century, as the Pale got stronger and other parts were colonized by the English. There was a conflict between them, and sometimes one predominated and sometimes the other did, depending on the mix. And it was only, I think, in the 17th century that it was decided that the Brehon laws were evil and obscene, and they were done away with. But as I understand it, different aspects of the Brehon law continued within and was practiced by some of the English nobility because it was the law respected by the people they had to deal with. So it was easier to get them to accept laws that were consistent with their own laws. And even if their English overlord didn't accept the Brehon laws, as I understand it, many of the Irish in disputes among themselves in the old tradition didn't go to law but settled it with one of the wise people of the community, probably clergy at that stage. But it was a mixed, evolving thing over several centuries. But did the English common law learn from it? I believe it did. I truly believe it did. There's a fair number of citations in England from the Irish courts, a surprising number. And I suspect part of that might be the development of the common law incorporating some of these very common sense principles.
I just don't want to let you get away entirely.
Good for you.
The Scots, were they talking about the Irish law and the English law? What about the Scots?
There's no question that when I'm talking about the wave of people the Celts who came from northern Spain, they came into Ireland and eventually, over the centuries, into the Western Isles and the Highlands of Scotland. The Scots. They were called the Scots in Ireland, and that's where the name Scotland came from. But they, of course, carried the law with them as well in different forms, slightly different forms, perhaps. But the Scots law, the remnants of the Scots law, which is significant from the Act of Union and so on, carried with it a lot of the tenor and the sense of the old Brehon laws and the Highland laws. But again, the predominance obviously was the Lowland Scots there because of their power and the English influence. Question here?
Yeah,
Charlie.
How was the Brehon selected? Did the two parties have to agree to that? And secondly, who paid?
The losing party. I believe it was the losing party, but I think in some instances they both had to. But if they're disputing over a piece of property, I really can't answer that. And the selection was among the Brehons, so you had to be a reputable, good Brehon to get work, so to speak, because like our arbitrators today, the labor arbitrators, for example, they're usually chosen on a selected basis where both sides agree. They split the cost, usually. And part of that, may have had some roots as well in this system. But if you had a bad reputation as a Brehon, you were out of work.
I'm interested, Bill, in I gather the system is rather individualistic in the sense that offenses providing against other individuals indicate commencement that the state per se was not highly organized, but yet they make communities. Today, I think most of our offenses are against a long series of provincial statutes or federal statutes, and fines are paid into government and so on, as opposed to compensating individuals. Did they have offenses against the community much, or were they usually always identified as offenses individuals. You mentioned the case of murder, that there was the atonement and compensation paid to the widow and the family. Where would these fines go in the instance of judges, which you mentioned? The judge made a erroneous decision or accepted a bribe and paid a fine. Where would that one go?
Well, usually it would probably go to the person wronged, or I think, as far as I know, it always went to the person wronged. I don't think it went to state treasury, if that's what you're thinking. But I'm not really sure of that, Charlie. That's a good question. I'll try and master that one for the next one. But I'm not sure. But one of the things I didn't discuss tonight because of lack of time was that there was a very strong kin group, or finna, in which was protective of the individual members within its society. And when I mentioned, I think at one stage when there was a fine, it went, for death, it went to the relatives. But often the fine would be distributed by the kin group. The kin group owned a lot of the land, for example, what we would call common land. If a person wanted to get kindling in the woods that belonged to the the finna, they would have to, they were assigned, each family, a certain amount that they could take out of the woods each year, if they were a member of that kin group. But there's a lot more to it, as you can imagine. There are literally dozens of texts of different types of law. And when you think that each competent Brehon had to memorize texts of laws and commentaries on laws, you can imagine the feat that must have been. But that's the best answer I think I can give you in the circumstances. Yes, sir.
Was there an identifiable sector of society that would challenge the Brehon?
No, not that I'm aware of. And that, I think its strongest aspect of the Brehon laws was its public acceptance by the people, because of course they weren't dealing with the state, the powerful oppressor, often in the eyes of many people, and they weren't dealing with a judge appointed by the state. They were dealing with someone they had chosen and that they were paying for, and because of the religious aspect as well, the mysticism involved, they respected it and they accepted it. And they knew in a small integrated culture like that if they didn't have that glue to the culture, that perhaps there would be more difficulties for them. But they accepted it. It was the honorable thing to do, to accept a decision against you. And if you failed to do that, then you could even lose honor from it. Anything else?
You said the Brehons were from an island.
I meant to say Ireland if I said island.
Just generally from Ireland.
Yes.
Small island.
Well, I won't go into that, but I think there was a small island where the Druids would train a lot of the various levels of Druidry, including the memorization skills and including the laws, but that was in very, very ancient times, and I didn't read that as part of the laws, but I think there is basis in that. I can't think of the name of the island. Perhaps Brendan, you might remember. I guess that's it. Thank you very much.
Judge
Judge
Kelly, according to fair to his people, according to the law.
I'm sorry, who fair?
Or the monarch.
Oh, yes. Yeah, that's a good question, because most societies break down when the king or the rulers or the state ignores the law. But this was the acceptance of the law by the king was unquestioned almost in Ireland, in ancient Celtic Ireland, because the king could lose his rank if he ignored the law. And because he'd lose his honor price, and the king had an honor price the same as the craftsperson had an honor price, and it was accepted by the kings, and they kept one Brehon very close to him, and to advise them in that respect. So almost without question, there's very little, I think, in the records that indicate a king would deliberately and openly flout the law, because there was what was called a judgment of the host. And as we try to translate that, not me, but others try to translate that in what was meant by it, and they suspect that it means that if a king breaks the law and no one corrects it, the people, a large group of the people, or a powerful part of the group of people, a host, will rise up and dethrone him. And I think that that was the ultimate threat for the state and the king obeying the law.
Thank you very much, Justice Kelly. We'll have an opportunity when we break to speak to Justice Kelly individually. A few announcements before we do break. I want to tell you some of the activities that are coming up here at the Irish Society as we move into St. Patrick's Week. Tomorrow evening there's a ceilidh here at the hall, dancing and singing and all kinds of good times. Next week the play is on here, Finnegan's Wake, on the 11th, 12th, and 13th. Okay. What's that?
We have some tickets here.
Morris says we have some tickets here, so if you're interested in attending the play, you best get them tonight, because the play is very, very popular and may be sold out very quickly if past years are anything to go by. So see Morris or Alan Molyneux or some of the other fellows who are here this evening. Then next Saturday is the St. Patrick's Banquet. Next Sunday is the parade. So anybody and everyone who wishes to be in that parade, you don't have to be a member of the society, you don't have to be Irish, you just have to want to get out there on St. Patrick's Day and parade. You're invited to meet, I imagine it's down at the rec center as usual, 10 o'clock. And then Monday is St. Patrick's itself. There will be some activities out here at the hall. We announce on Monday the 17th the official kickoff for our fundraising campaign for our Irish Settlers Memorial. The announcement hopefully will be here at the Society, and hopefully we'll have a mass of media here to give us a good send-off. There are brochures around. If you're interested in supporting that project, we'd appreciate your money. You know, we will refuse it from no one. You don't have to be Irish. You can be Acadian, Scottish, Jewish. We will not discriminate on the basis of race, creed. Just give us your money, for God's sake. Before you leave, if you haven't signed your name as you come in, please do so. So we'd like to keep track of the numbers, and we also, particularly for new people, want to keep you or get you on the mailing list for future events. And finally, next Friday night, we have a very interesting lecture as well, and it's especially important because it's being co-sponsored by our kith and kin, the Scots, and the name of the lecture is Scots and Irish, One People, ?